Okay, ladies and gentlemen, my name is Agnieszka Gryszczyńska and I'm a professor at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. I wish to welcome you on the sixth scientific seminar titled Electronic Evidence in Criminal Proceedings. The seminar will focus on evidence law issues. Cybercrime poses many challenges to law enforcement agencies due to the difficulty of collecting evidence. There is a lack of unified legal regulations as well as universal good practices for investigators. At the meeting, we'll address legal regulations related to preserving electronic evidence in domestic and international law. We have 6 members of the cybercrime team presenting their papers at today's seminar. Moreover, we have one keynote speech concerning challenges of electronic evidence. I would like to warmly welcome keynote speaker, Professor Jerzy Kosiński from the Polish Naval Academy Command and Naval Operations Faculty, and express my thanks to him for joining our seminar. At today's seminar, the first introductory lecture titled Challenges of Electronic Evidence will be given by Professor Kosiński. Jurek, the floor is yours. I don't see Jurek anymore. Where is Jurek? I think that I have to give the presenter role once again to Professor Jerzy Kosiński. Jerzy?
One moment, please.
You have to
now I'm okay, but
your screen once again because
before the seminar we tried all. Okay.
We can see your presentation. Everything is working properly, so the floor is yours.
Good afternoon for all. At today's meeting, I would like to share with you some thoughts about the challenges facing experts who examine electronic evidence. However, let me start by reminding you of the rules of the evidence, which are unchanging. Although in the CSI series movies, we see that forensic experts often use magic rather than the science principles. Standards and working procedures related to electronic evidence are different from country to country. There are a few key standards that many countries follow, such as ISO 27037 or 17025. However, much of the digital forensic and incident response community believes that these standards don't reflect the rapidly changing environment. The mobile and IoT devices examination best illustrate the challenges facing the forensic examination of electronic evidence. Among these challenges are lack of standardization in this field. I said about it before, but not only in terms of process tool implementation, but also investigative models, disruption of existing good practices. For example, we don't modify the state of secured devices, or how much software or hardware can be tampered with on the secured device or related platforms. Keeping up with requirements, changes in policies, procedures, and concepts, often of an ambiguous nature. keeping up not only with technology but also with the activities being conducted by criminals. Variety of devices, technologies, and infrastructures to keep up to date with. Variety of artifacts that can be found on a device or related platforms. The reasons of these challenges are different, but among them are hardware dynamics. New models of mobile devices appear frequently. Expert knowledge will never cover all devices and operating systems. Continuous learning is necessary to stay abreast of technological advances. Many brands and models of cell phones. The same models may differ in a single component, but there are also niche products and clones of mobile phones. Dynamics changes in application used on mobile devices. The challenge with apps, as with devices, is that apps change all the time, and with each new version, tools vendors have to re-evaluate apps and how data can be accessed or not. Forensic toolkits unfortunately don't support all apps. They support dozens to hundreds or different applications. Most often, they provide support for apps commonly found on mobile devices or those that are popular with users. Support also depends on the app version. Apps often store most information and data in their own databases. For example, in SQLite. The continuous introduction of new features and applications that are built into smartphones or available on demand. This puts additional pressure on experts to stay abreast of new crimes, techniques, and opportunities that can be exploited and those that should be considered in a case. The continuous evolution of applications and features is an advantage for users, but the complexity of these features and update cycles is a problem for those examining the device. The next challenge are built-in security features. They may complicate the process of accessing data. They may prevent access to data altogether. Device manufacturers have moved toward robust security features that are built to protect user privacy by design. Developers of forensics tools must constantly keep up with changes in applications, data storage, file systems, security features. Tool reliability is critical, and as the number of devices and data grows, so does the dependence on tools, especially as the use of some tools appears early in the criminal case. Locking mechanisms. Access codes are the norm for gaining access to any mobile device. Encryption. The iPhone encrypts all data on the device by default, using hardware keys built into the device. Android enforces encryption by default for the user data partition. There are brute force methods and workarounds for encryption locking mechanisms. but they never guarantee the effect. Data, not the device itself, is usually the most valuable element of the device. And there are a lot of them. A significant portion of these zettabytes are on electronic media. These large amounts of data require automating the survey. One of the more effective methods is to use artificial intelligence and most often machine learning. ML is great for clustering, pattern detection, and anomaly detection. However, artificial intelligence can fail because of immanent weakness in machine learning algorithms, abuse against our artificial intelligence systems by malicious actors, by criminals. Unfortunately, it's important to remember that statistical error will occur when using machine learning. It is possible wrong indication of evidence or failure to detect evidence. The large amounts of data are often stored in the cloud, and this raises legal and organizational issues. Access to and from the cloud can be challenging and may even be restricted in some jurisdictions. As a result, we have limited or untimely access to data in the cloud. There are also technical problems, additional security mechanisms that must be bypassed, and in addition to regular data storage, cloud backups may be important. Cybercriminals are very creative in making it difficult to conduct a forensic examination of media and devices. We can encounter encryption, obfuscation, data hiding, steganography, metadata manipulation or corruption. We can find hidden secret applications, device modification, malware, and many other anti-forensics activities. Earlier, I listed a lot of problems, but on the other hand, all forensic software vendors claim that mobile forensics is simple. All you need to have, for example, Celebrite or MSAB tool or Oxygen forensic magnet or another one. One manufacturer's website states, no longer do you have to be a forensic expert to extract data from phones. Now anyone can do it. This is very strong thing and very bad thing. And this is where the biggest challenge comes in, the knowledge and skills of experts. Automation in digital forensics has become commonplace. However, reliance on tools cannot be unconditional. Summarizing the indicated challenges, it can be generalized that well-planned, careful use of automation must coexist with improving the overall quality of forensic experts. And of course, This should be applied to the forensic examination of all electronic media. Thank you very much for your attention.
Thank you, Professor, for your presentation. The law do not keep up with the challenges of the complexity and diversity of devices. As an expert in computer forensics, how do you assess the Polish regulation on electronic evidence and the regulation of forensic experts?
I can say that I haven't any obstacles to the legal form, but to the practical, because in our situation, the best expert is the cheaper expert, not the best. And this is the biggest problem with this situation.
We have a discussion in Poland about uh, are the computer forensic expert are really experts, and we are thinking about some certifications programs for witness experts, because as we know, uh, the forensic expert role in the criminal proceedings is really crucial. And if we give the devices, even for the simple extraction of data, to improper experts, we can not be succeed in the court.
In my opinion, it is too easy to stay a court expert, because if you buy such tools and if you want to be, you will be the court expert without any exams, without any certifications, without any qualifications.
Okay, we have a keynote speaker, so I ask if there are any questions to our expert witness, to our keynote speaker, that who is also a forensic expert and prepare a lot of expert witness opinion for in criminal proceedings. You can also ask a question using a chat section on the platform, so or by just turning on the microphone. Okay, I don't see any question to our keynote speaker. So thank you, Jerzy, very much for your presentation. So if there are no questions, I wish to proceed to the next presentation titled Forensics Aspects of Preserving Digital Evidence, that will be presented by Professor Rafał Wielki, who is an assistant professor and the deputy dean at the Faculty of Law and Administration at the University of Opole. So today's meeting, we are starting with issues related to forensics and practical issues related to electronic evidence. So, Professor, the floor is yours.
Thank you very much, Professor. Dear colleagues, dear guests, good afternoon. I was listening to this discussion about forensic experts or expert witness in the field of computer science. I think in Poland we have a much broader problem, much bigger problem with forensic experts, because definitely we don't have any system that certifies qualifications of the people who work for criminal justice, and still for over 30 years we don't have act on expert witnesses. So the problem is much larger than we think. think. But today I would like to focus on the case of those forensic aspects of preserving digital evidence that might be the basics with conducting investigations during the situation when some electronic evidence appears in criminal cases. We have a problem with changing realities forced by advances in economic and social life that also affect the criminal world. As we already know from the number of seminars in this year's project and the last year's edition, criminals are operating brilliantly in the digital world, which is causing a qualitative changes in crime, and so we are facing an increase in cybercrime cases. Moreover, there is a steady increase in the number of crimes committed using electronic devices or ICT systems. So perpetrators often leave digital traces rather than physical traces. So this forces a slightly different approach to the problem, as well as the evaluation and standardization of other methodological standards. While forensic science has developed standards for dealing with physical traces, generally, because we don't have standards for all evidence, but they are universal, independent from the law in many countries. But in the case of digital traces or electronic evidence, it's still evolving. Mystic by the examination of electronic devices that is presented in mass media, we can say that the image of police officer that's searching the content of a user's phone is very often presented as a standard. However, this should not happen. And however, I must say I experienced it by myself one time when a public officer wanted me to show my phone calls, my conversation, all pictures on my phone. But I must admit that it wasn't in Poland. It was in a different country. But this is not the situation that's expected in today's times. This approach in principle is not correct, I think, and evidence obtained in this way should be considered unreliable due to the risk of conscious or unconscious manipulation of data. We should consider the few things. I mean, the computer or any device. By computer, I mean any device that could be a PC, that could be laptop, smartphone, whatever. This device can be, or information stored at this device. It can be stored as an executable object. So, for example, the computer or its components from the theft or the software installed on the computer does not have appropriate licenses. This is one situation. Also, we should consider that the computer could be an instrument of criminal acts. So, for example, software installed on the computer may be used to break security features in foreign systems or to forge documents. Also, the computer or the information stored in the computer can contain evidence of some other crimes. For example, a drug dealer can store information about suppliers or have an instant messenger installed on the computer used for communication. And so we have the situation when the computer serves both as an instrument of crime and stores information that can be evident. For example, the cracker uses a computer to attack other systems and stores stolen credit cards information on it. For these reasons, electronic evidence requires a specific approach through the proceedings, from preservation to analysis and presentation in the court of this evidence. Hence, good practices that take care of authenticity and fidelity of the evidence are important here. What's the most important about those basics? We should consider that the equipment and media be secured should be properly labeled, described in protocols, and sealed. That's not. This doesn't happen every time, unfortunately. Also, the evidence should be preserved in the state at the time of securing, with accurate record of date and time of examination. Data retention should be based on the creation of a copy created on equal basis with the original copy. So we mean binary copy. Authentication of material is possible by calculating the checksum of media or files at the time of securing. Forensic examinations should be also exclusive on the copy, so as not to affect the evidentiary value of the original material. It should allow other experts to work on the same material. So we work on the copy. We should work on the copy when it's, of course, possible. But if it's not possible, if the research or examination is carried out on the original, it should be carried out using techniques that prevent alternation of data records contained in the information medium. However, before starting the activities, every expert should consider, is there a point in prohibiting a computer device? Usually, computer records are in direct evidence and do not identify the perpetrator. So maybe it's worth considering, is it enough to secure data instead of computer, for example? There are some practical tips that are considered as best practices, like not changing the current state of the device. So if the device is off, it must remain off. If the device is on, it generally must remain on. But taking any action should be consulted with forensic expert before. Also, there is a question: can we leave the data in open space or unsecured area? Of course not. We should make sure that the device is not left unattended in open or unsecured area. Documents such things as the device is located and who has access to it when it's moved should be approved. There is also a good practice to not connect any external storage media to the device, because memory cards, flash drives, or other storage media change the temporary memory of devices. It's also worth mentioning that we should not copy anything from or to the device, because copying anything also changes the free memory space. It's a good practice to take a picture of the evidence, I mean physical picture, that's connected to the papers of a criminal case, because it shows how the evidence was secured from all sides. If it's, for example, a cell phone, it's worth taking pictures from all sides to make sure that device has not been tampered with until forensic expert arrived. Also, however, it's not possible in every case. We should make sure that we know the PIN or password pattern of the device. it's not good to open anything on these devices, such as pictures, apps, files on the device, because opening any application file or image on the device may cause data loss or overwrite memory on such a device. This is a good practice also for investigators, because we have a lot of people that remain that they are experts, but really their knowledge is not quite good. We shouldn't trust anyone without specific forensic training. Only a certified forensic expert should be allowed to examine or review files on the original device, for example. Untrained people, in fact, can cause some data losses or deletion of data. So it's not a good practice. Uh, Maybe we should discuss also a few things considering methods of forensic experts' work, because there are three main. However, they are not only methods that are used before we start examining any electronic device or electronic trace. First, we say about drive imaging. Before forensic investigators begin analyzing evidence from some source, they need to create an image of the evidence. So, imaging a drive is a forensic process in which analysts will create a byte by byte duplicate of the drive. When analyzing a forensic image, expert needs to keep up some crucial points that even wiped drives can retain important and recoverable data to identify. Forensic experts can recover all deleted files using forensic techniques, and generally they shouldn't work on original media. A piece of hardware or software that helps facilitate the legal defensibility of forensic image is right blocker, which forensic investigators should use to create the image for an analyst. Second thing is hash values. When investigator creates an image of evidence for analysis, the next process is to generate the cryptographic hash values that are critical, as they are used to verify authenticity and integrity of the image, as an exact replica of original media. Also, when admitting evidence in the court, hash values are critical, as altering even the smallest byte of data will generate a completely new hash value. Uh, when performing any modifications, like creating a new file or editing an existing file on computer, new hash value is generated for this file. Also, we should remember that hash value or and other file metadata are not visible in normal file explorer windows, so analysts can access this information using some special software. However, it's not often very special. We should also remember that if the hash value of image or original evidence do not match, it might raise some concerns in court that the evidence has been tampered with. And the third thing is chain of custody, because as forensic investigators collect media from the client, transfer it, they should document all the steps conducted during the transfer of media and the evidence of chain of custody forms, as well as signatures, dates, times upon the media handoff. Also, it's essential to conduct chain of custody paperwork due to the following reasons. Because chain of custody demonstrates that the image has been under known possession since the time the image was created. Any lapse in the chain of custody nullifies the legal value of the image and also the whole examination. And also any gaps in the procession records, like time of evidence was left unattended in open space or secured location, are problematic. So to conclude, technology can be extremely complex, and although the evidence presented may be very relevant, the party presenting it needs to ensure its value is highlighted, and not only in the complexity of underlying technology, as can be the case with, for example, cloud-based evidence. But consequently, investigating time and developing a technology plan for the court is considered as time well spent, especially when defendant's lawyer is using a strategy of making the technology sound as a complex of as complex as possible to the jury. If we have technological evidence and it's highly complex, it's good to have an independent, great expert witness who knows little about the case and about the technology, helps to present the court with understanding of the crucial technology in the case without any doubts. This person that is an expert witness to the court is the core, we can say. A problem is that many juries don't understand the problems of new technologies. So I think we can consider that many lawyers also have problems with new technologies. There is one thing that the handling of electronic evidence differs from this physical evidence. Its proper preservation and examination has similar standards in the terms of taking care not to contaminate the traces or to preserve the authenticity. Certainly, we can say that electronic evidence has individual features not found in other forensic examinations. That is, ability to create copies of traces. This is a facilitation in many situations, but it's worth remembering that there are strict standards of procedures that are being developed. The key seems to be international cooperation of services, unification of standards for handling electronic evidence, regardless to the norms of criminal procedural law in individual countries. Due to this international nature of cybercrimes, I think that this aspect seems particularly important in the context of real fight against this cross-border crime that is cybercrime, in fact. Thank you very much for your attention, and if you have any questions, I will be more than happy to answer them.
Thank you very much for your presentation, Rafał. Are there any questions to our speaker? I would like to invite you to ask questions by using a chat section on the platform or by raising hand or just turning on the microphone.
I've got not question, but one note, because you said about the hash value of the image of the drive. Now it is a very big problem with the SSD drives, because you can calculate many times the same drive. Calculated hash will be different, can be different. We can move calculation of hash value checksums to the part of the drive, not for whole drive.
Yeah, to the partition, yeah.
Okay, any other comments or questions? Okay, so thank you very much, Rafał. And now we are moving to this part of our seminar where we will discuss the regulatory issues and law related to electronic evidence. For the next speech, I would like to ask Piotr Burczaniuk, representing Department of Theory and Philosophy of Law of the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw, to present a paper related to a new European regulation on European production orders and European preservation orders for the acquisition of electronic evidence. So new rules, new regulations. We hope that this regulation will help us to acquire electronic evidence. So Piotr, the floor is yours.
Thank you, Professor. I suppose you can see my presentation. So to the topic.
We can see, we can hear, so everything is okay.
On July 28th this year, new regulation number 5043 of the European Parliament and of the Council of July 12th, also this year, on European production orders and European preservation orders for electronic evidence in criminal proceedings was published in the official journal of the European Union. Legislative work on the act in question lasted more than 5 years, exactly since April 18th, 2018, when its draft was adopted by the European Commission. The draft itself was part of a legislative package aimed at strengthening cross-border cooperation in combating serious crime. The regulation which was adopted will be in effect from August 18, 2026, and is estimated by the European legislator as a milestone in cross-border investigations in the European Union. As indicated in the recitals to the regulation, currently, in order to obtain electronic evidence, authorities of European Union member states rely on long-standing judicial cooperation procedures based on, first, on Directive number 41 of April 3rd, 2014 regarding the European Investigation Order in criminal matters. It provides for the possibility of issuing European investigation orders for the collection of evidence in another member state. Second, the Convention on Mutual Assistance in Criminal Matters between the member states of the European Union, which also provides for the possibility of requesting evidence from another member state. However, the procedures and deadlines provided for in both acts, as practice shows, do not correspond then to the conditions for obtaining electronic evidence. This evidence is, of course, less permanent and can be easily and quickly deleted. As a result, member states are increasingly using direct cooperation with service providers. Thus, in turn, is leading to diversification of national tools, conditions, and procedures for such cooperation. In turn, this process, according to European Commission, lack credibility, transparency, responsibility, and legal certainty. The new regulation thus introduces provisions under which the competent authority of an EU member state may issue: first, a European Production Order Certificate, abbreviated as APOC; second, a European Preservation Order Certificate, abbreviated as APOC-PR. Both orders are intended to serve directing requests to a service provider from another member state to produce or secure electronic evidence, respectively, regardless of the location of the data. According to Article 3, Item 8 of the regulation, electronic evidence is, first, subscriber data, defined by the regulation as any data held by a service provider relating to the subscription to its services. Second, traffic data, defined by the regulation as the data related to the provision of the service offered by the service provider. Third, content data, defined by the regulation as any data in digital form, such as text, voice, video, images, and sound. All of this data must be stored electronically by the service provider when it receives a certificate for one of the two orders. Importantly, as Article 1 indicates, the regulation is without prejudice to the power of national authorities to ask service providers operating in their territory to apply national measures similar to the European measures indicated. Turning to the first of the orders, according to Article 3.1 of the regulation, a European production order means a decision ordering the production of electronic evidence issued or validated by the judicial authority of a member state and addressed to service provider offering services in the Union where designated establishment or legal representative is located in another member state. In the case of a request for traffic or content data, only the judicial authority will be the competent issuing authority. Subscriber or user identification data, on the other hand, will be available for acquisition on the basis of a warrant issued by a public prosecutor. A European production order to obtain traffic or content data can only be issued if the data is necessary and proportional for the purposes of criminal proceeding concerning, first, offenses punishable in the issuing state with a maximum term of imprisonment of at least 3 years. Secondly, offenses defined, catalogued in the regulation, including these commit in whole or in part using an information system. In addition, the European production order requires that a similar warrant can be issued under the same conditions in a domestic case. In the case of subscriber data, the same conditions apply, but in these cases, European production order can be issued for all crimes under criminal investigation. Most importantly, that European production order will be addressed directly to the service provider. Importantly, however, in some cases of requesting traffic or content data, the issuing authority must notify the competent enforcement authority in the member state where the service provider is established. The authority is required to evaluate the case quickly, a maximum of 10 days. During this time, it can decide to refuse on grounds including the protection of fundamental rights or immunities and privileges. Upon receipt of a European production order, the service provider must immediately secure the requested data and forward it within 10 days at the latest directly to the issuing authority or to the law enforcement agency indicated in the warrant. In cases of emergency, the service provider must hand over the data without undue delay and within 8 hours of receiving the warrant at the latest. Turning to the second order, according to Article 3, Paragraph 2, a European preservation order means a decision which orders to preservation of electronic evidence for the purposes of a subsequent request for production and which is used or validated by a judicial authority of a member state and addressed to a service provider offering services in the Union where that designated establishment or legal representative is located in another member state. Pursuant to Article 6 of the regulation, such an order may be issued for all offenses if it is necessary and proportionate to the purpose of preventing the deletion, erasure, or modification of the data to be covered by a subsequent request for such data under mutual legal assistance, the European Investigation Order or the European Production Order certificate, taking into account the rights of the suspect or accused. According to Article 11 of the regulation, in the case of European Preservation Order, the service provider must secure the requested data without undue delay. The obligation to secure the data expires after 60 days unless the issuing authority confirms that another request for evidence has been issued. This period may be extended by an additional 30 days if necessary to allow for the issuance of another request for evidence. Importantly, according to Article 1.2 of the regulation, the European Production Order and European Preservation Order may also be requested by a suspect, defendant, or professional representative acting on behalf of such a person under the applicable right of defense in accordance with the provisions of national criminal procedural law. All applications, including APOC and APOCPRs, shall be filled out in the forms attached to the regulation, fragment of which can be seen on the presentation. The regulation applies to service providers that offer services in the European Union. In Article 3.3 of the regulation, they are defined as any natural or legal person that provides at least one of the following categories of services. First, electronic communication services as defined in Article 2.4 of Directive number 1972 of 2018. Second, Internet domain name and IP numbering services, such as IP address segment, domain name registry, domain name registrar, and domain name related privacy and proxy services. Third, another information society services, as referred to Article 1.1b of Directive number 15635 of 2015, that enable the users to communicate with each other, storing or otherwise processing data on behalf of the users to whom the service is provided. According to Article 3.4 of the regulation, a service provider is considered to offer services in the European Union if it enables natural or legal persons in a member state to use the services listed above, and if it has substantial connection based on certain factual criteria with the member state. Such a significant link is considered to exist when the service provider is established in a member state, when there is a significant number of users in at least one member state, or when the service provider directs its activities to at least one member state. It is worth noting that, according to Directive number 1544 of July 12, 2023, published in the official journal of the European Union on the same day as the regulation, member states will have to ensure that all service providers offering services in the European Union designate a legal representative or designate facility to receive, comply with, and enforce requests for the collection of electronic evidence. Failure to comply with the orders discussed may result in sanctions for service providers. According to Article 15 of the regulation, member states must adopt provisions for fines for violations of the enforcement of European Production Order or European Preservation Order. These penalties are to be effective, proportionate, and dissuasive. In this regard, member states must provide for the possibility of imposing fines of up to 2% of the service provider's total annual worldwide turnover from the previous fiscal year. At the same time, in accordance with the aforementioned directive, member states will have to ensure that both the designated company or legal representative and the service provider can be held jointly and severally liable for non-compliance, so that each can be subject to penalties. In addition to fines, the regulation introduced through Article 16 regulations covering coercive proceedings. It includes detailed rules for the enforcement of orders by a designated coercive authority acting at the request of the requesting state. Summarizing the above, it is undoubtedly agreed that the regulation under review may represent a significant step forward in the possibilities of cross-border acquisition of digital evidence in the European Union. Despite this, its practical effectiveness seems to be severely limited. This is because the Act, in addition to simplifying and speeding up the procedures for obtaining evidence, does not touch the issue of data scope. It leaves outside the regulation at all in the issue of data retention or data encryption. Regarding the second problem, moreover, recital 20 of the regulation explicitly indicates that it should not affect the use of encryption by service providers or their users. It should not lay down any obligation for service providers to decrypt data. Thus, despite the simplifications introduced for obtaining data, it is likely that much of it will prove to be inaccessible or unusable due to the encryption protection in place. It seems that both issues required further analysis in the context of formulating specific legislative demands. That's all. Thank you very much for your attention.
Thank you, Piotr. Are there any questions to our speaker? Okay, I don't see any questions or comments. If you would like to ask a question or to comment on a presentation, you can also use the chat section on the platform. So if there are no further questions, I wish to move to the next presentation, titled Regulation Concerning Electronic Evidence in Hungarian Law, that will be presented by Professor Erika Ruth, who is head of the Institute of Criminal Sciences at the Faculty of Law, University of Miskolc. Erika, the floor is yours. We can see your presentation.
Okay. Thank you. Thank you so much, Agnieszka. I try to change the screen. Okay. Just a minute. Okay. Can you see my presentation?
No, we cannot see your presentation. You have to share your screen once again. Maybe I will give you the presenter role. Maybe something is wrong with your role here on the meeting. Now you are the presenter.
Try again.
So maybe now it will be fixed.
Yes. Probably now you can see my presentation, I hope.
Yes, now we can see your presentation.
Yes. Okay, and I tried the slideshow. Can you see my second slide as well?
No, I think you sharing not the proper screen, or you are sharing not the whole screen, but only the PPT. Now we can see the second slide. Now it is visible.
Okay, it will be the best solution as it was earlier.
Okay, it's visible, it's okay, so you can just change the slides like this, it's not a problem.
So thank you so much. At the beginning of my presentation, I will speak a little bit about the increasing role of electronic evidence in the criminal procedure. And after that, the concrete Hungarian legislation, um, especially how to obtain electronic evidence. And I will introduce some coercive measures which are applicable to obtain and preserve electronic evidence. And after that, I try to summarize my presentation. The emergence of electronic data as mean of evidence in criminal proceeding and its increasing role in evidence procedure is a good example of the impact of technological developments on legislation and law enforcement. At the same time, we must not forget that electronic data appear as a means of evidence not only in cybercrime cases. That is why the legal provisions on the acquisition and preservation of electronic data go far beyond the scope of cybercrime. As Zoltán Nagy, our colleague in Hungary, wrote, the range of crime that cannot be committed by computer is getting narrower. More and more criminals are using technology to plan and commit offenses. As a result, authorities are increasingly rely on e-evidence to track down and convict criminals. I agree with Levulis, who wrote that the importance of digital evidence extends to the prosecution of all types of crimes in all jurisdictions. Regarding crimes committed in the cyber environment, the most part of evidence based on digital data. Many authors underline that to collecting evidence to prove facts is more difficult in cybercrime cases than in other cases. Electronic data can be changed and deleted quickly, and thus the evidence can be destroyed and falsified. Determining the place where the digital data was created and uploaded sometimes means insurmountable tasks for law enforcement agencies. One of the reasons for this is that the IT service providers often unwilling to cooperate, but without their help, collection of evidence is a difficult or impossible task. Similarly, clarifying the user's identity can be extremely difficult, taking into account that the same system is frequently used by several people. What is e-evidence? Electronic evidence or e-evidence refers to digital data that is used to investigate and prosecute criminal offenses. Digital evidence is a data, so it is not a tangible thing. Data doesn't exist in itself. It is only recorded by some data medium. But for example, as I know in Poland, there is no legal definition of digital evidence. Regulation of electronic data in Hungarian Code of Criminal Procedure is quite complex. Electronic data could be used in the course of evidence in criminal proceedings even before the entry into force of the current Criminal Procedural Act. The difference was that the former Act, Act 19 of 1998, didn't provide for it under a separate title, but allowed the use of the object recording the data under the provision on the physical evidence by means of an expanding interpretation. The link with the physical means of evidence is still detectable despite the independent appearance of electronic evidence. According to our code, wherever this act refers to physical evidence, it shall be understood to include electronic data unless otherwise provided by this act. So in cases where common provisions cannot be made for electronic data and the physical means of evidence, the law doesn't contain a specific rules. The electronic data are treated as a physical means of evidence. The reason for naming electronic data as a new means of evidence in the new code was that it cannot always be treated in the same way as physical things and thus as physical means of evidence. It is a fact that when the former code of criminal procedure was adopted, electronic data didn't have the same significance as it does today. As the electronic data was used more and more frequently in evidence procedure, the legislator tried to follow the technological developments. It is also likely that after a short while, the current law will also need to be amended because of technological development. How does the Hungarian Code on Criminal Procedure define electronic data? According to the section you can see in the slide, electronic data means any representation of facts, information, and concepts that is suitable for being technically processed by an informatic system, by an information system, including any program that ensures the implementation of a function by the information system. This definition is the same that the Budapest Convention says defining computer data. What is meant by an information system is defined in the criminal code and by the code of criminal procedure, literally the same way. Information system means an equipment that ensures the automatic processing, management, storage, and transfer of data, or a set of such equipment in connection with each other. Electronic evidence may be difficult to collect owing to the volatility of data and may require specific expertise, as our keynote speaker said. In the process of obtaining and collecting electronic data, particular care must be taken to ensure that their authenticity cannot be questioned. Otherwise, their use before the court will fail and they will not be accepted as evidence by the court. The success of proving crimes committed in the IT environment is decisively influenced by the fact whether the investigating authority or the public prosecutor can ensure electronic data proving the commission of the crime during the investigation. In criminal proceedings, not only proceedings concerning cybercrime cases, but all cases where electronic data should be used as evidence, the access to electronic data stored in other countries is crucial. In the EU adoption of new rules to speed up access to electronic data started in 2018, as Piotr mentioned, when the European Commission prepared a proposal for regulation, and now this regulation is adopted. It was adopted, as Piotr mentioned also, on 12th of July in this year, and it shall apply from 18 August 2026. In cybercrime cases, certain special knowledge may be necessary to determine what kind of evidence should be collected and which cursive measures, if any, should be used in order to collect them. Since the possibility of using electronic evidence may emerge in more and more cases, there is a constantly increasing demand for the expertise and opinion of an IT or computer expert in criminal proceedings. Authorities acting in criminal cases can use open and covert means to obtain the evidence necessary to establish the facts of the case. The use of covert means raises several constitutional problems because fundamental rights of citizens might be violated. Therefore, it is of utmost importance that the use of covert methods should be permitted only in exceptional cases in accordance with the principle necessity and proportionality. As with other means of evidence, the acquisition of electronic data is primarily carried out by non-coercive procedural actions, but it cannot be excluded that this can only be done by applying coercive measures restricting the fundamental rights of the data subject. Traditional coercive measures were also mostly suitable for searching and preserving of electronic data and information system under the previous Code of Criminal Procedure, but the legislator has continuously expanded the relevant provisions. Coercive measures for the collection and preservation of electronic data fall within the scope of coercive measures affecting assets. Now I will speak briefly about search, seizure, including as a special coercive measure, the obligation to preserve electronic data and the rendering electronic data temporarily inaccessible. The search may include the inspection of an information system or data medium. Search may be ordered if it can be reasonable to assume that it leads to, among others, the discovery of a means of evidence and the examination of an information system or data medium. Access to electronic data is not the most common purpose now of ordering research, but according to the second sentence of the paragraph 1 of the section 302 of our code, search may also include searching an information system and data storage medium. The specific subject matter of the search of the information system or the data carrier is underlined by the fact that the government decree number you can see on the slide contains relatively detailed provisions on how to take coercive measures concerning these specific subjects. In the information system, examinations are carried out which may not be possible later, is written by one of our colleagues. During the search of IT system, it must be ensured that data accessible through the system remain unchanged during the inspection and recording. Crucial is the ability to prove that the content presented in court is exactly the same as the one captured during the investigation. Since not all police stations have the necessary means to carry out coercive measures and police staff lack the necessary knowledge on certain special issue, they often have recourse to external assistance, the external help. The expert or specialist consultant is the person who carries out the task on the spot and has the tools that are essential for the successfully executed procedural act. In accordance with the requirements of the Budapest Convention, the Hungarian Code on Criminal Procedure regulates the seizure of electronic data as a special type of seizure and the ordering of preservation of electronic data. It has to be mentioned that these rules are only relatively new. The seizure of electronic data and ordering to preserve them was also regulated in the former Code of Criminal Procedure. The new code only redefined the former rules, but these changes were important and are important. Although the seizure of electronic data is a special case of seizure, in the Hungarian code, there is no special rule concerning the seizure of electronic devices, and thus the general rules applies even if the seizure of electronic data is necessary in the criminal proceeding. In connection with criminal offenses, it may be necessary to seizure not only the data, but the device also, laptop, flash drive, and so on. They are sized as physical evidence according to the practice established in relation to traditional offenses. According to our regulations, seizure of electronic data may be carried out by making a copy of electronic data, by transferring the electronic data, by making a copy of the entire content of the information system or data medium containing it, by seizing the information system or data medium containing it, or by any other means provided by law. The mentioned order of methods of seizure means order of application as well. The solution with the most significant limitations seizing the information system or data carrier can therefore only be used as last resort. Detailed provisions on the application of different methods of execution of seizure can be found in the joint degree. You can see the number of it on the slide. If the seizure of electronic data is necessary for the purposes of criminal proceedings, it is not usually necessary to seize the information system, computer server, or data medium containing the electronic data. The reason for this is that from the point of view of evidence, the data itself is relevant, which can be obtained from the information system or data medium containing electronic data in a number of other ways, copying, data transfer, and so on. I describe it above. When electronic devices are seized, their carefully packaging and transport are also very important from the point of view of the subsequent examination of data and consequently the effectiveness of the evidence. Devices containing digital data must be protected from physical impact and from electric and magnetic fields. The involvement of an expert during a research is not mandatory by the code. The code only provides an opportunity for it. However, it is useful if the expert is present and he can examine the data medium and electronic devices on the spot. He can also help to decide whether something needs to be seized or not. The special method of seizing electronic data used for payment was first defined in the currently effective code. Preservation of electronic data is not a new provision as well. The predecessor of the current coercive measure can be found in our old code since 1st January 2003. It transposed the requirements set out by the Article 16 of the Budapest Convention into domestic legislation. Later, the name of the measure was modified, but it is not important now. It is important, but due to the time limit, I try to cut my presentation. So the preservation of electronic data could be the part of seizure of electronic data. It may be ordered in order to detect or prove a criminal offense. The person obliged to preserve electronic data is obliged to keep the electronic data specified in the decision unchanged and provide secure storage for these data separately from other data files if necessary to prevent the modification, deletion, destruction, transfer, unauthorized copying of electronic data and unauthorized access to them. If, despite the best efforts of the person obliged to preserve electronic data, the data are assessed, modified, deleted, and so on, he must immediately inform the authority ordering the preservation of electronic data. Since the purpose of the ordering this measure is to preserve data that may be important from the point of view of the detection or evidence in an unchanged state, after the order is issued, the authority that ordered it shall start the examination of electronic data. As the preservation obligation lasts for a maximum of 3 months. The last cursive measure I would like to mention is the rendering electronic data temporarily inaccessible. The introduction of these measures, the introduction of the measure called rendering electronic data irreversibly inaccessible into the criminal code and the insertion of cursive measures enabling the temporarily inaccessibility of electronic data into the Code of Criminal Procedure was primarily required by the obligation stemming from the Directive number 93 of 2011. The cursive measure was introduced in the Code of Criminal Procedure in connection with the entry into force of the new criminal code. It was a logical legislative step to have a procedural counterpart of the criminal measure to prevent access to illegal content. The background of this cursive measure is the measure rendering electronic data irreversibly inaccessible, and Ferenc will speak about it. Rendering electronic data temporarily inaccessible may be ordered when the proceeding is conducted regarding a criminal offense subject to public prosecution in connection with rendering electronic data permanently inaccessible may be ordered, and doing so is necessary to interrupt the criminal offense. In addition, to my presentation, I wanted to speak a little bit more about forms of rendering electronic data temporarily inaccessible, but I have no time, so I go further and summarize my presentation. As I said, and not only me, but other colleagues, the importance of electronic evidence has increased in recent years. Their use is not only important in cybercrime cases, but other cases as well. Obtaining electronic evidence is often very difficult. And why it is difficult, we could identify the following reason for this. Data can be quickly changed or deleted. Maintaining anonymity is not a challenge now for the perpetrators. IT service providers are often uncooperative. Obtaining data from other countries with the tools of international criminal cooperation also causes difficulties. We hope that the new regulation will prevent these difficulties. The members of the acting authorities often do not have adequate information technology skills. Thus, it is necessary to involve an expert or special consultant. And the rapid IT developments may require frequent amendments to the relevant legal regulation. Thank you for your kind attention.
Thank you, Erika, very much for your presentation. Are there any questions to Erika? I hope everybody could see the presentation because Professor Kosiński wrote a message that there were some problems with visibility, but I think it was only, let's say, individual problems. So if everything is okay, I would like to present my presentation. Okay.
Agnieszka, I can see now that you have written some message for me, but when I am when I share my screen, I cannot see messages. So.
No, it's not a problem. I was corresponding with Professor Kosiński, and we, let's say, fixed the problem with the visibility. So it was only individual problem. I think login, rejoining the meeting just fixed all problems related to the visibility. I saw your presentation all the time, and nobody, let's say, also had the same problems. So I'm trying to be on the chat section all the time. So if there are any issues related to the presentation, I'm trying to fix the problem immediately. Okay, I hope you can see my presentation. So, ladies and gentlemen, what would be the main issue related to my presentation? We were talking about some specific challenges related to cybercrime cases, and we know that cybercrimes do not know national borders. So criminals, victims, technical infrastructure span multiple jurisdictions, bringing many challenges to investigations and prosecutions. And cybercrime is a growing problem for many countries. That is why facilitating cross-border access to electronic evidence is a pressing issue concerning almost any type of crime. Moreover, evidence of any criminal offense is increasingly stored in electronic form on computer systems in foreign, multiple, or unknown jurisdictions. If we are talking about electronic evidence refers to various types of data in electronic form that are relevant in investigations and prosecuting criminal offenses, and are often stored on the servers of online service providers. This includes content data and non-content data. So we can divide electronic evidence on content data and non-content data very generally. And more than a half of criminal investigations today require access to cross-border electronic evidence. Electronic evidence is needed in around 85% of criminal investigations, and in 2/3 of these investigations, there is a need to obtain evidence from online service providers based on other jurisdictions. The number of requests to the main online service providers is growing. So these types of data are essential in criminal investigations to identify a person or to obtain information about their activities. What are the problems? Talking about electronic evidence should always be followed by terminological and methodological considerations. This is where the first problem arises, the lack of definition of electronic evidence. The definition of electronic evidence does not only exist in Polish law, but also in the Budapest Convention or its second additional protocol. So there is no acceptable common definition on electronic evidence. The concept of electronic evidence is being replaced by the concept of evidence in electronic form or a digital evidence. As we heard today, there is a regulation about European production orders and European preservation orders, and there is a definition on electronic evidence. So we can see that this concept refers to subscriber data, traffic data, content data stored by on behalf of a service provider in an electronic form. But this definition is quite short. So if we will analyze the data necessary for the proceedings, we noticed that they are very diverse. They range from logs to various services, telecommunications data, content data, subscriber data, financial data necessary to conduct financial flow analysis. We can also analyze the main data providers, and there are many categories of subjects from whom data can be requested in ongoing criminal proceedings. Online service models, providers, the range of data they collect, and the length of the time they store data are changing dynamically across the world. What is also problematic, the part of the data is available online and it is sufficient to perform open source intelligence, so-called OSINT, to access them. And paradoxically, the determination of the data necessary for the proceedings has been made significantly more difficult by the GDPR regulation. Many domain registers citing GDPR do not publish data in WHOIS databases. And paradoxically, those data are available in EURIT register for EU domain. So it makes much more difficult to attribute the attack and establish the perpetrator's infrastructure. The only data of value for law enforcement, as you know from the practice, is the email address, because other data are mostly from identity theft. And so it is a practical problem we observe. The next problem is the problem that we have to collect and stored data from various data storage devices. Some of the data storage devices will also become substantive evidence in criminal proceedings. This evidence will be forwarded to computer forensic experts for extraction and analysis of the stored data. In ongoing investigations, it will therefore be necessary to carry out searches at the identified locations in order to determine the items to be seized. In view of the wide variety of Internet of Things devices, this activity is complicated even if it's carried out in the country where the proceedings are conducted. If data carriers and data are located in other locations, the complexity of securing for criminal proceedings increases significantly. So, of course, we have some regulation. I do not present this regulation here because we do not have time for this. But the current European Union legal framework consists of cooperation instruments in criminal matters. A new regulation was shown by Piotr. And of course, we have to. We know that the cooperation between judicial authorities is the traditional method for authorities to work together to tackle all types of crimes, but it's not effective. So, when taking into account the volatile nature of electronic evidence, taking an average of 10 months for providing data, this can entail a disproportionate expense of resources. So it is problematic. So we now observe the new regulations and the regulations that gives us the possibility to receive data directly from service providers. And the good example is a second additional protocol to the Convention on Cybercrime. So it is a basis for asking providers for disclosure of domain name registration information and for direct cooperation with service providers for subscriber information and effective means to obtain subscriber information and traffic data. Another idea to better combat cybercrime is the adoption of the new Convention on Cybercrime. The ad hoc committee to elaborate a comprehensive international convention on countering the use of information and communication technologies for criminal purposes held its sixth session from 23rd August to 1st September this year in New York. At its sixth session, the ad hoc committee considered all provisions contained in the draft text of the convention, but there was no agreement on very basic concepts. According to the current working draft of the convention that is available on the website of ad hoc committee, the objective of the convention include, among others, the collection and exchange of electronic evidence. However, the convention does not contain a definition of electronic evidence. There is also no agreement on whether the convention is to refer to the collection of evidence in electronic form only for offenses established in accordance with the convention, or more broadly for serious crimes, or even more broadly to any crimes. The inclusion in a convention, the possibility of collecting evidence in electronic form in cases other than the offenses covered by the conventions, was intended as a position to reducing the scope of criminalization and reducing the number of offenses covered by the convention that can be committed using information and communication technologies. So if we go further, we can see the definitions included in the convention. No compromise was reached on all relevant definitions. In particular, works is ongoing on definition on computer system or information and communication technology device. There is no agreement which, let's say, definition should be acceptable. There is also no definition on computer data or digital information. But with regard to definitions affecting the scope of electronic evidence to be collected, the draft conventions contains a definition of traffic data, the definition of content data, the definition of subscriber information, the definition of service provider, and the definitions of freezing or seizure, confiscation, and the property. So those definitions are, let's say, under agreement. There is also no agreement on whether the convention is to refer to the collection of evidence in electronic form only for offenses established in accordance with the convention or more broadly, and it is also visible in the Article 23 scope of procedural measures. So there is no agreement if the procedural measures of the convention also includes other crimes and collection, obtaining, preservation, and sharing of evidence for any offenses or offenses established in accordance with this convention. On my slides, you can see which countries are, for example, including specific wording, or which countries are against including specific rules to the convention. So you can see how the discussion looks like. The convention contains regulation relating to expedite preservation of stored computer data or digital information, because there is no agreement which wording should be chosen. Expedite preservation of accumulated electronic information, expedite preservation and practical disclosure of traffic data, production order, search and seizure of stored computer data, digital information, alternatively, information stored or processed electronically, real-time collection or interception of traffic data, interception of content data. Unfortunately, there is no agreement on most procedural measures, and it is not certain that an agreement will be reached at the last ad hoc committee meeting in January 2024. There are also provisions in the conventions for which there is no majority agreement, which are not provided for in the Budapest Convention, like retention of electronic information or article about admissibility of electronic evidence. As far as the admissibility of electronic evidence is concerned, most countries consider that this is a matter to be regulated by national law and not by the international conventions. So, for example, the European Union and its member states are for deleting this article, as well as the next article that refers to establishing relevant legal procedures and technical standards for the collection, retention, and provision of electronic evidence to ensure the authenticity, integrity, and legality of electronic evidence. So also this point, according to most member states and countries represented on ad hoc committee, thinks that this is to be regulated in national law, not in the international convention. Convention also includes instruments known from the Budapest Convention, like 24/7 network. So those measures well known from Budapest Convention. But there is also something, for example, new. So article that referring to cooperation between national authorities and service providers. So the cooperation, according to this article, shall include also, for example, promptly preserving electronic evidence to prevent loss or modification. My time is finishing, but before conclusion, I would like only show one practical example. I would like to introduce you a Polish cybercriminal, Tomasz, known as Tomasz or Armageddon. Why I would like to focus on this perpetrator? He was well known in Poland. He was a Polish citizen, but he lived in Belgium. A lot of articles on the internet you can find about him. Europol published information about his arrest, showing that it was a prolific cyber criminal. And as you can see on this picture, he was responsible for Polish ransomware known as Flotera, and he was really hardworking cyber criminal because he encrypted more than 16,000 devices in Poland. So we collected decryption keys and we collected more than 16 decryption keys. That means that that he was really, let's say, hardworking, and a lot of ransomware campaign was made by him. As I said, Tomasz was a Polish citizen, but he lived in Belgium. He was arrested in Poland, but his computers remained in Belgium. So if we are talking about international cooperation in preserving electronic evidence and this things related with electronic evidence, why did I present this example? The data carriers of Tomasz were seized on the basis of European investigation order in a country with a similar law located in Europe, in European Union. The basis for the search was European Union and the national law. There were no doubts about the procedural safeguards for the suspect or his rights. There were no doubts about procedural measures. However, it took almost a year, exactly 11 months, for the evidence to be released to Poland. It is not an isolated example. Even the best convention will not make us effective in conducting cross-border proceedings In practice, if practice does not change and if the procedural steps for preserving electronic evidence are not carried out promptly. So to conclude, cooperation on cybercrime and the collection of evidence in electronic form of any criminal offense for the purpose of specific criminal investigations or proceedings through additional tools per training to more efficient mutual assistance and other forms of cooperation between competent authorities, cooperation in emergencies and direct cooperation between competent authorities and service providers and other entities in possession of control of pertinent information. It is really crucial. Mutual assistance is not always an effective way to process and increasing number of requests for volatile electronic evidence. And of course, we have to remember about safeguards, which shall provide for adequate protection of human rights and fundamental freedom. And this discussion about human rights and fundamental freedom is really very visible if we go through the works of ad hoc committee for the new convention on cybercrime. So thank you very much for your kind attention. If there are any questions, I would be very happy to hear them.
Agnieszka, according to the Thomas, is Thomas already convicted or no?
No, but the case is in court.
Thank you very much.
So the indictment was sent to the court. Okay, I have to now provide the presenter rule to the next speaker. If there are any further questions, please don't hesitate to ask them. And now...
Sorry, Professor. As always, Judith will help me to the presentation. So you please. You
okay, because I just changed this and I just okay. So Judith would be a presenter. Erika, Judith or Erika? Judith.
Judith. Yeah.
Okay, so I will change it. So Judith would be a presenter and Ferenc would be a speaker. Okay, so I would like to ask Ferenc from Miskolc University, Department of Criminal Law and Criminology, to present a speech rendering electronic data permanently accessible in Hungarian criminal law. Ferenc, the floor is yours.
Yes, thank you very much, Professor, and thank you for the help of Judith. As the Professor mentioned, the title and the topic of my presentation today is rendering electronic data permanently inaccessible in Hungarian criminal law. And the next slide, you can see the subtopics of my presentation. First of all, I would like to outline the international background of measures, criminal measures against websites containing illegal content, namely the directive of the EU from 2011 on combating the sexual abuse of the children. And next, I will give an overview. Of the special criminal measures, namely rendering electronic data permanently inaccessible. About the legislation in our Hungarian criminal code, and finally, since Erika did not have enough time to introduce the special coercive measure namely rendering electronic data temporarily inaccessible, I will give a short overview of this cursive measure. In the next slide, we can see the international background, but first of all, I note some introductory remarks about the topic. In the case of cybercrimes, and in particular some offenses committed on the internet, it is essential to prevent access to illegal data and the continuation of the offense. Such crimes include child pornography, hate speech, misleading of consumers, copyright infringements, or crimes against property committed on the internet. However, until 2012, there was no sanction in Hungarian criminal law to make illegal content inaccessible, so the possibilities for the authorities to fight against cybercriminals were very limited. The introduction of the new legislation was also required by Hungary's obligation to harmonize EU law. The obligation was based on Article 25 of the Directive on combating the sexual abuse and sexual exploitation of children and child pornography. You can see the relevant provisions of the directive, and as you can see, this is the measures against websites containing or disseminating child pornography. And the first case, this is an obligation for the member states, because member states shall take the necessary measures to ensure the prompt removal of web pages. And the second case, this is a possibility, since member states may take measures to block access to web pages containing or disseminating child pornography. And in compliance with the obligation to harmonize our criminal law, the Hungarian legislator has extended the list of criminal sanctions in our new criminal code with a new criminal measure called rendering electronic data permanently inaccessible. In parallel with introducing this new criminal sanction, a new coercive measure was also necessary during the criminal proceedings, targeting the prevention of continued online criminal activities and access to forbidden data content. This is how the Criminal Procedure Code also incorporated provisions on rendering electronic data temporarily inaccessible as a coercive measure. Currently, Hungary has a wide variety of legal measures, criminal law, administrative law, and civil law measures concerning blocking, filtering, and takedown of illegal internet contents. Now I will focus the related measures of our criminal substantial law and criminal procedure law. In the next slide, you can see the relevant legislation of rendering electronic data permanently inaccessible according to our criminal code. The data published on an electronic communications network shall be rendered permanently inaccessible. The disclosure or publication of which constitutes a criminal offense, or which is used as an instrument for the commission of the crime, or which is created by the commission of a crime. As I mentioned above, in the Hungarian criminal sanction system, rendering electronic data permanently inaccessible is a security measure which can be imposed independently or together with a punishment or other criminal measure. In contrast to punishments, which require a criminal offense to be committed with culpability, this criminal measure can also be applied to perpetrators who are children or mentally ill, or even if the perpetrator is not punishable due to the ground for exemption from criminal responsibility. Our criminal code do not define the electronic data, but according to the legal literature, electronic data can be defined as data published on an electronic communications network by an electronic communication service provider, which can be identified by IP address, URL, domain name, and port number. And as you can see the next slide, in principle, this measure can be applied for any crime, but the criminal code defines the electronic data covered by the measure in a taxative manner. Data, the disclosure or publication of which constitutes a criminal offense, for example, child pornography, copyright infringements, electronic data used as an instrument to commit an offense. For example, in the case of fraud committed through an information system, a fake website used by the perpetrator which was similar in an internet banking login page. And thirdly, electronic data created by the commission of an offense, for example, a defamatory communication. It is important that the criminal court shall specify in the judgment the electronic data covered by the measure, and you can see in the slide an example of the court ruling. And the next slide, you can see the fulfillment of the measures, two types of the fulfillment. There are two types of the fulfillment: deleting the data and permanently blocking the access to the data. Let's see the first, the deleting data, which is the responsibility of the web hosting provider, who is obliged to remove the electronic data. The court specified the hosting provider in the judgment exactly: name, address, registered office, name of the representative, and so on. And the court issues a notice requiring the hosting provider to delete the data within 1 working day after receiving the judgment, or send the notice to the state tax authority for enforcement of the measure. If the web hosting provider fails to comply with the obligation to delete the electronic data, the court may impose a fine from 100,000 forint to 1 million forint on the basis of a notice from the tax authority, and the fine may be imposed again and again. And the second types of the fulfillment of the measure is the permanently blocking the access to the data. In this case, the court sends its judgment to the National Media and Info Communications Authority, which organizes and supervises the enforcement of the judgment. The electronic communication service providers who provide access to the data are obliged to block access to the electronic data. These service providers are internet access providers. You can see some example: search providers and cache providers. And if you can see the next slide, the National Media and Info Communications Authority contributes to the prevention of cyber crimes generally. The authority operates the so-called CATHA, the Central Electronic Database of the decisions on rendering data inaccessible. In this database, the authority stores and processes the decisions sent by the court and forwards them to electronic communication service providers, as well as searching providers and caching service providers. Under the court decision, internet access providers are obliged to block access to the electronic data identified in the decision within 1 working day and filter it from internet traffic. Search providers and cache providers are also obliged to block access to data found or stored as a result of a search for the data identified in the decision. If service providers fail to comply with this obligation, the court may impose a fine, as I mentioned earlier. And in the next slide, yes, I like to mention some thoughts about rendering electronic data temporarily inaccessible, because the mentioned criminal sanction, the mentioned criminal measure, namely rendering electronic data permanently inaccessible, may be enforced after the judgment has become final. However, in case of several content-related cybercrimes, it is very important to prevent the continuation of the offense by making the data inaccessible at an early stage of the criminal proceedings. This is the purpose of the new coercive measure introduced by the Criminal Procedure Code in 2013, namely the rendering electronic data temporarily inaccessible. The relevant article of the CPC provides the definition of this coercive measure. You can see this definition, but it is an important question. What are the general conditions for applying the measure? You can see the general condition, and as I remember, Erika mentioned these conditions. So I emphasize that two different types of these coercive measures. The first is the temporarily removal of the electronic data, and the second is the temporarily blocking of access to the data. And in the next slide, you can see the first type of the measure, the temporary removal of the electronic data. In principle, this type of measure can be applied for any crime if the mentioned conditions are met. The obliged parties are the web hosting providers. They shall be obliged to temporarily remove the electronic data within one working day after receiving the court order. And important to note that if the court has not applied in its final judgment the criminal sanction rendering electronic data permanently inaccessible at the end of the procedure, the court shall order the web hosting provider to restore the electronic data. And the second type of the measure, the temporary blocking of access to the electronic data, this type of measure can only be applied to the crimes listed in the Criminal Procedure Code. These crimes are drug trafficking and other crimes related to drugs, misuse of new psychoactive substances, child pornography, crimes against the state, crimes related to terrorism financing. If a web hosting provider failed to comply with its obligation of temporary removal, or it would be impossible to identify the hosting provider required to remove the data, or a foreign authority has made a request for legal assistance for the temporary removal of the data, but this has not been successful within 30 days, or a foreign authority should be contacted for the temporary removal of the electronic data, but this would not be expected to produce any results. And if we can see the next slide, in this case, the obliged parties are the electronic communications service providers that are obliged to temporarily block access to electronic data. The court shall immediately send electronic notification to the National Media and Infocommunications Authority about its measure. The authority organizes and supervises the execution of the measure, and in doing so, the authority enters the obligation to block the data in the mentioned central database, informs the service providers of the court's decision, who are obliged to temporarily block access to the electronic data within one working day after receiving the information, and the fine may also be imposed for non-compliance in this case as well. And It is important the court lifts the measure if the web hosting provider complies with its obligation to remove electronic data temporarily. The reason for applying the measure has otherwise ceased to exist, or the investigation has been terminated. And I note that for the sake of the smooth international cooperation, the Act on International Legal Assistance on Criminal Matters provides the possibility to the Hungarian authorities to use the procedural or enforcement legal assistance available to render electronic data temporarily or permanently inaccessible if the website is hosted by a foreign web hosting service provider, and vice versa. The act enables the Hungarian authorities to fulfill such foreign requests for legal assistance if the web hosting service provider is Hungarian. And if we see the next slide, as for the relevant case law concerning this special criminal measure, the official collection of the Hungarian Supreme Court, the Curia, does not contain any decision concerning the criminal measure of rendering electronic data inaccessible, but I found some judgments in the anonymized decisions. I would like to mention one. In 2015, there was a criminal trial before the Criminal Court of Miskolc for threatening to commit a terrorist crime. The accused threatened to execute the members of the Hungarian parliament in a post on the internet if they do not adopt a new act to protect debtors of foreign currency loans in Hungary. During the investigation, the court ordered the coercive measure and rendered the temporary removal of the electronic data. The court of Miskolc, may be interesting, acquitted the accused, taking the view that the accused did not seriously mean his threat, so the threat was not a real, serious one. However, the Court of Appeal, the Court of Second Instance, found him guilty because, according to the court, the seriousness of the threat was irrelevant. Consequently, the Court of Appeal ordered the permanent inaccessibility of the electronic data containing the threat publicly posted on the website and obliged the web hosting provider to permanently remove the electronic data. And my last sentence, that I have reviewed the sanction system in Polish criminal law, and I hope that I'm right. I have not found a similar criminal measure as the Hungarian rendering electronic data permanently inaccessible. So I think that the Hungarian legislation concerning this criminal measure could be a good example for Polish criminal law. Thank you for your attention. Thanks.
Thank you very much for your presentation, friends. The final conclusion, I can only agree. We do not have general regulation on that, and it can be a problem. We sometimes can manage in this because we have specific regulation, but only for specific cases. So are there any questions to the speaker? I don't see any questions in the chat section on the platform. So if there are no questions, I would like to ask Professor Judith Jaszo, who is the head of Department of Criminal Law and Criminology and Vice Dean of the Faculty of Law and of the University of Miskolc, for the presentation titled The Confiscation of Criminal Property. Professor, the floor is yours.
Just a moment. I could not find my PPT. Okay. Could you see?
Yes, we can see your presentation.
Here. Okay. Thank you. Thank you so much. The topic of my presentation today is the confiscation of criminal property. After some introduction remarks, I would like to give you an overview about following topics. I would like to talk about the history of the regulation of the confiscation at the level of the European Union. After that, in the next part, I would like to give you an overview about the new development in this field at the level of the European Union, because there is a new proposal of the EU for a directive on asset recovery and confiscation. And finally, I would like to emphasize some remarks about the regulation and practice of the criminal sanction of confiscation in Hungary. Yes, it should be noted that the main motive for cross-border organized crime, as well as cybercrime, the financial gain, since illegal activities generate profits. Confiscation of the proceeds of crime is generally one of the most effective tools in the fight against crime and therefore against cybercrime. Confiscation has also a preventive effect, which is intended to discourage offenders from committing the crime. However, the Moneyval drew attention in its report adopted in 2022 that successful confiscation of criminal assets are relatively rare compared with the estimates of the proceeds of crime. Europol estimates that only about 2% of criminal proceeds are frozen and 1% confiscated in the EU. You can see on the next slide the process and several phases of the asset recovery process includes. In my presentation, I would like concentrate on confiscation of the illegal assets. And about the current legislative framework in the European Union, some words. The legislator of the European Union established a directive in 2040 on the freezing and confiscation of instrumentalities and proceeds of crime in the European Union. The previous EU legal framework in this topic were joint action and framework decision, but it was not efficient. It must be noted that there are other EU legal documents that deal with confiscation which contain procedural provisions. As we know, the judicial cooperation in criminal matters in the European Union is based on the principle of mutual recognition of judgment and judicial decisions. From our aspects, it is important to underline the EU regulation from 2018 on the mutual recognition of freezing orders and confiscation orders. The different types of freezing orders and confiscation orders covered by that directive from 2014 should also be included in the legal framework of mutual recognition. In this field, there were several Council framework decisions, but they were not fully effective because they have not been implemented and applied uniformly in the member states of the European Union, which has led to insufficient mutual recognition and suboptimal cross-border cooperation. And thirdly, it should be mentioned the Council decision from 2007 concerning cooperation between asset recovery offices of the member states in this field of tracing and identification of proceeds from or other property related to crime. Member states should have national asset recovery offices which are competent in these areas and should ensure that these offices can exchange information rapidly. You can see there is a network of these offices. And it should be mentioned that the international standards for confiscation is included in several international conventions too. In the Warsaw Convention adopted by the Council of Europe in 2015, it is currently the comprehensive international binding treaty worldwide, which is developed to anti-money laundering directive. It covers prevention, repression, and international cooperation as well, confiscation. Okay, and after that, I would like to speak about the current legislative framework in the European Union. In the framework of our project, we have already discussed several EU criminal law directives, which aims to harmonize the substantive criminal law of the member states. These directives concern the scope of the criminal conduct to be criminalized. However, the directive from 2014 is different, as the legislative aim was to harmonize a criminal sanction within the EU. In addition to the substantive criminal law provisions on confiscation, the directive also contains procedural rules, safeguards, administration, or procedural guarantees. In the preamble of the directive, the EU legislator stressed that among the most effective means of combating organized crime is providing for several legal consequences for committing such crime, as well as effective detection and freezing and confiscation of the instrumentalities and proceeds of crime. This is also true for cyber crimes and cyber laundering too, which are most often carried out in an organized and cross-border form too. However, without international cooperation between the competent judicial and administrative authorities, it is not possible to combat effectively against cybercrime. The aim of this directive was to make it easier for national authorities to confiscate and recover the proceeds from crime in the EU. The directive sets out minimum rules for freezing and confiscation the proceeds of crime. Those minimum rules concern the confiscation of proceeds of crime. Confiscation means a final deprivation of property ordered by a court in relation to the criminal offenses. There are there are provisions about extended confiscation and confiscation from a third party. The directive also contains provisions on the freezing of property with a view to possible following confiscation. Freezing means the temporary prohibition of the transfer, conversion, disposal, or movement of property. You can see on the slide the scope of the directive. This is limited to certain areas of crimes. And 11 euro crimes are listed. You can see money laundering and for our aspect relevant directive on attack against information system were includes. And after that, I would like to speak shortly about the new development in this area in the European Union. In order to ensure that crime does not pay, the Commission announced in its EU strategy about organized crime that it is intends to strengthen the rules on asset recovery and confiscation, taking into account to 2020 Commission report. After that, the Commission adopted a proposal for a directive on asset recovery and confiscation in 2022. There were several justifications for updating the legislation. The practical reason was that the legal regulatory framework of the listed crimes has changed since 2014. The framework decisions, which was listed in the previous directive, have been replaced by directives, and in addition, there are another more new directives with criminal matters. The aim of the new directive is, in accordance with the opinion of the Commission, undertakes to amend and the substantive criminal law and criminal procedural provisions of the old directives, as well as the policy law provisions, and regulates all the relevant provisions in the single legal act and to extend them in various ways. However, the new legislation would not only update the directive, but would also significantly extend its scope. You can see on the next slide, Article 2, about the scope of the proposal of the new EU directive. And after that, some words about the confiscation in the Hungarian criminal law. The sanction system of the Hungarian criminal code follows a dualistic approach. It means that in the Hungarian criminal code, we can find two types of sanction, penalties and measures. The confiscation of property belongs to the group of measures. The most important difference between them is that the penalties can only be imposed on punishable natural persons, while part of measures can be applied in case of the commission of an unlawful act, even if the perpetrator is not punishable based on different grounds. For example, confiscation of property can also be applied if the perpetrator cannot be prosecuted for reason of minority or insanity, or due to other grounds for exemption from criminal responsibility. According to the criminal code, the following shall be subject to confiscation of property. You can see the cases of the confiscation on the slide, and I would like to emphasize that it is important to highlight that the criminal code also enables the confiscation from third person. If the commission of the criminal offense severed to enrichment of a third person other than the perpetrator. However, according to the judicial practice, confiscation of property cannot be ordered for assets that must be returned to the victim of the crime, or that have already been returned to the victim. Furthermore, it also was to emphasize that confiscation of property may not be applied if any payment obligation has been imposed by definitive decision of the administrative authority or the state tax or customs authority, or by final court decision in an administrative action on the same factual basis as in the criminal proceeding concerned, up to the amount of such payment obligation. This provision corresponds with the principle nebis in idem. The Hungarian Criminal Code also enables a so-called extended confiscation of property. The aim, and it is very important, I think, the aim of these rules is to facilitate the proving of the illegal origin of the assets and the reverse the burden of proof. According to these rules, all assets obtained by the perpetrator by participation in a criminal organization, commission of illicit trafficking in narcotic drugs or human smuggling shall be subject to confiscation unless the perpetrator can prove the lawful origin of the assets. Furthermore, if the criminal offender commits one of the crimes listed in the criminal code, all assets obtained in the 5 years proceeding, the criminal proceedings, can be confiscated if the size, assets, and the lifestyle of the perpetrator is considered unreasonable relative to his lawful income and personal circumstances. However, the proof to the contrary can be possible in this case as well. And you can see we have a provision about the confiscation of property corresponding to the value of illegal proceeds. It is possible in accordance with the Hungarian Criminal Code. And after that conclusion, the application of confiscation is even more challenging in case of cybercrimes for the authorities due to the technology involved and transnational nature of cybercrime. It is possible to confiscate cyber asset as proceeds of cybercrime. In the proposal, in the preamble of the proposal of the Commission from 2022, it was mentioned this sentence: the keeping or sealing its value is very important in this case. It could be a relevant provision that it is possible the confiscation of property corresponding to the value of the illegal proceeds. And I think in this field is very important that we have harmonized regulation. Thank you very much for your attention.
Thank you very much, Judith, for your presentation. Are there any questions? I don't see any. Okay, so today's agenda of our seminar is finished. So thank you very much for attending our meeting. Thank you for attending our 6th and the last Open Scientific Seminar. Thanking you for attention. We wish all the speakers further fruitful research, and all of you an enjoyable afternoon. So thank you very much for your presentation, and I think we will see each other in person on the conference on November. So thank you very much, and see you on the conference concluding our research.
Thank you very much.
Thank you so much.
See you soon.
Thank you very much.
Thank you. Goodbye.
Thank you very much.